Good morning, everyone. I'm Paul Richards, the interim chairman of today's meeting. Thank you for joining us. I would like to say welcome to the stakeholders, and this is the 8th meeting of the Joint Select Committee on the Miscellaneous Provisions Local Government Reform Bill 2019. I thank you for joining us today. We have quite a bit to get through. At this time, I'd like to advise that the public hearing is being broadcast on Parliament Channel 11 and Parliament Radio 105.5 FM, and also the Parliament's YouTube channel, ParlView. At this time, I'd like to invite members of the committee to introduce themselves. There are 3 members, inclusive of the substantive chair, Minister Ambrot, who are unable to be with us today, and also included in that list of excused members are Mrs. Camille Robinson-Regis and Mr. Esmond Ford. I'd like to invite members to introduce themselves. Starting on my right, Member Amchar.
Anthony Garcia, member.
Good morning, Derup Timal, member.
Good morning, Rudranathan Dar Singh, member.
Good morning, Kazim Hussain, member.
Good morning, Khadija Amin, Opposition Senator, member of the committee.
Thank you, members. And at this time, the entities before us include the Office of the Auditor General, the Office of the Chief Personnel Officer, the Office of the Ombudsman, the Service Commissions Department, the Statutory Authority Service Commission, and the Trinidad and Tobago Police Service. So at this time, I'd like the principals of those groups to please introduce themselves, starting with the Deputy Commissioner.
Yes, morning everyone. Hari Krishnan Baldev, Deputy Commissioner of Police, Trinidad and Tobago Police Service.
Good morning, members. Yujfa Ali, Executive Officer, Statutory Authority Service Commission.
Good morning, members. Christopher Thomas, Chairman of the Statutory Authority Service Commission.
Good morning, Chairman and members of the committee. I am Mrs. Deborah Parkinson, Director of Personnel Administration, Acting Service Commissions Department.
Good morning, everyone. Marcia Pilo Brady, Executive Officer, Office of the Ombudsman, representing the Ombudsman.
Good morning, Chair and members. I'm Angela Siniswi-Gervais, Chief Personnel Officer of the Personnel Department.
Good morning, Chair and members. I am Laurelie Pujadas, Auditor General of the Office of the Auditor General.
Good morning, Anita Mangra, Senior Legal Officer, Office of the Auditor General.
Good morning, Susan Ali, Senior Human Resource Advisor, Personnel Department.
Good morning, everyone. Mrs. Dalmati Rampasad, Senior Investigator, Office of the Ombudsman.
Good morning, everyone. I am Mrs. Parvati Anmol Singh Mahavir, Deputy Chairman, Public Service Commission.
Good morning, Natasha C. Charan, Legal Advisor, Service Commissions Department.
Good morning, Margaret Morales, Executive Director, Human Resource Management, Service Commissions Department.
Good morning, Kenneth Parker, Deputy Chairman, Statutory Authority Service Commission.
Good morning, Louis Hernandez, Assistant Auditor General, Acting Office of the Auditor General.
Good morning all, Shiva Sananan, Assistant Auditor General, Office of the Auditor General.
Good morning, Nipanji Kernan, Acting Head Legal, Office of the Ombudsman.
That's it, we got everyone. Thank you all, and I'd just like to advise you when you are responding to questions or comments by members of the committee, please direct your questions through me and turn your microphone on so that we can hear you and the listening and viewing public can also hear you. At this time, I'd also like to invite the principals of each of the group to deliver brief opening remarks. Let's start with the Office of the Auditor General.
Good morning, Chair. The Office of the Auditor General welcomes this opportunity to meet with the members of the Joint Select Committee to discuss this very important aspect, the bill, which is dealing with the local government reform. We will contain ourselves further as we progress in terms of what the contents of the bill as it impacts on the work of the Auditor General and as it impacts on certain comments that we would possibly need to be clarified in terms of how we're proceeding to go forward. And so at this time, that is all I want to say, and say thank you again, once again, for giving us the opportunity to be here.
Thank you. Can we have the Office of the CPO next, please?
Good morning again. The Personnel Department welcomes this opportunity to assist the Joint Select Committee with its deliberation on the miscellaneous provisions Local Government Reform Bill 2019. The Personnel Department is responsible for determining and advising on pay and terms and conditions of employment of a wide range of persons in the public service. Through consultation and negotiation with the appropriate recognized associations and unions, the department determines terms and conditions of service for monthly paid officers of the civil service, teaching service, police, fire, prison services, and the statutory authorities subject to the Act. The department is also responsible for the determination of terms and conditions of employment of daily rated workers and contract employees. We provide secretariat services for the Salaries Review Commission, which is responsible for determining terms and conditions for officers under its purview, as well as the Human Resource Advisory Committee, which is a subcommittee of Cabinet responsible for monitoring the levels of remuneration in the public sector. We also assist with a wide range of HR issues, including matters related to industrial relations. And again, we welcome the opportunity to provide any assistance possible. Thank you.
Thank you so much. Can we have the Office of the Ombudsman next, please?
Good morning, Chair and members. On behalf of the Ombudsman, we welcome this opportunity to make comment on the bill. It is noteworthy that since 2016 in the annual report, the Ombudsman of the Republic of Trinidad and Tobago commented that decentralization is the prime approach to improving public service delivery in Trinidad and Tobago. Local government reform should be seen as the pathways towards fulfillment of the covenant between the government and the people. It is expected that the parties must mutually work towards the improvement of quality of life of persons through the delivery of quality public services. It is hoped that such reform brings a reality municipal corporations will be better able to operate and more efficiently within the decentralized framework, allowing for enhanced delivery of services and stronger communities to exist, as decentralization largely aims to increase democratic quality, promote accountability, and administrative transparency. It is the Ombudsman's view that this management approach would deliver public services more efficiently by improving both allocative and productive efficiency and leads to more autonomous local authorities. The Ombudsman's view is that the decentralization can only be effective when appropriate accountability mechanisms are put in place. It is noted, however, that the complaints engaging the attention of the Ombudsman brought against regional corporations are usually due to the lack of financing of projects that would benefit citizens and presents major stumbling blocks. So it is the Ombudsman's view that this approach will, in fact, bring better service delivery. Thank you.
Thank you so much. Can we have next the Public Service Commission, please?
Good morning, Chairman and members of the committee again. The Public Service Commission wishes to indicate through the Office of the DPA its appreciation for being part of this discussion on the amendment of the Municipal Corporations Act, and particularly with reference to Section 35 of the Act, which confers the Public Service Commission the powers to appoint, remove, transfer, and exercise disciplinary control over officers of the corporation, as mentioned in the Act. The Commission, therefore, looked at the bill and is of the view that maybe, and the discussion will clarify, that some aspects of the bill may be contravention to its constitutional mandate and also infer or can impose duties on the Commission that may be ultra-vires the provisions of the Constitution. So I welcome the fact that we are here to discuss and possibly clarify some of the matters that are outlined in the bill so that the Commission will be able to exercise its function constitutionally. Thank you.
Thank you so much. Can we have the Statutory Authority Service Commission next, please?
Good morning, Chairman, all members of the Commission. The Statutory Authority Service Commission is pleased to meet with the Joint Select Committee to share its views on the draft bill before us. We appreciate the efforts that have informed the bill and its intended outreach. Nonetheless, we wish to seek clarification on some areas and ask that we do so even if we need to submit considerations after. First of all, two general statements. We appreciate the consideration in the bill on the standardization of the divisional structure to be adopted by all corporations, but would like to assess further the compatibility of the governing document of the JSC with certain aspects of the content of the bill. We also need clarification in relation to the uniformity of the divisions proposed in respect of all corporations. Further, we are of the view that clarification is needed on the following: the relationship between the Chief Executive Officer and the Council, the relationship between the Chief Executive Officer and the Permanent Secretary, the relationship between the heads of division and the council member responsible for the divisions, responsibility for completion of the performance appraisal report on members of staff, the responsibility for discipline in the new relationship. How are the recruitment and discipline aspects as set out in section 34 and 35, which make provisions for corporations and commissions to do those functions, to be reconciled? With respect to the municipal police, while the amendment, section 60, seek to make provisions for both commissions to be responsible for the regulations, the Statutory Commission observes that the municipal police operates as two separate groups, and they are governed differently. And as such, this amendment would not correct the issues in relation to this overall question. The clarification being sought on these matters is critical to the Commission providing a more in-depth analysis of the implications of the amendments outlined in the bill. Thank you.
Thank you. And the Trinidad and Tobago Police Service?
Yes, morning everyone. Again, on behalf of the Commissioner of Police, let me say I'm very pleased to appear before this panel. We at the Trinidad and Tobago Police Service willing to work with all the municipal police, traffic wardens, all the other stakeholders in order to make this bill a success. At the end of the day, it's for a safer Trinidad and Tobago, and we are always willing to work with these heads. Thank you.
Thank you. Well, let me start before I pass on to my colleague, Member Timal, with Mrs. Parkinson, the Director of Personal Administration, acting with the Service Commission Department, since you show that you've done your homework very well. And I'd like to ask you to elucidate for us what are some of the more critical conflicts you see, since you opened with that, in terms of your legal mandate, your constitutional mandate, and some of the provisions you see in this bill that are obviously from your utterances in conflict that we can start our deliberations on.
Thank you, Chair. I wish to ask my legal advisor, Service Commission's Department, to elucidate on this.
Absolutely.
Thank you. Good morning. The Public Service Commission has powers under the Constitution to appoint, promote, transfer, confirm, discipline, and remove all public officers. And prior to the bill, they did have power to appoint, remove, transfer, and exercise disciplinary control over the public officers, certain public officers in the corporations. We, like the Statutory Authority Service Commission, really do require clarification going forward on how it is to work. Because if we look at Section 3 of the bill, which proposes an amendment to Section 2 of the Act, it says that in the definition of commission, by inserting after the word act the words or the Public Service Commission, so that we proceeded then to do that insertion and look at all of these sections where commission occurs. And we were a bit concerned, for instance, with Section 60, which seems to now, it isn't clear because it says or, so we actually don't have the clarity, but it seems to now require the Public Service Commission to make regulations providing for the classification of officers in a municipal police service, including qualifications, duties, and remuneration, and providing generally for discipline, etc. So that this bit here in terms of qualifications, duties, remuneration, usually those are functions of the CPO, the employer. They are not functions of the commission according to the constitutional provisions. So we were unclear in terms of that. And in terms of the wider picture, there is a disparity in terms of how municipal police officers currently even are treated, because you would see that the commission has the authority to treat with a certain group of officers. This is the Public Service Commission, depending on which corporation they fall under, and then Statutory Authority Service Commission, they have jurisdiction over another set of officers. But you see the procedures in these two commissions are different, so it leads to inequality of treatment. So that I would urge, I think we would be concerned, that as you are engaging in reform, maybe you'd want to try to ensure that you give that equality to these officers, so that all the terms and conditions and provisions that relate to them would be the same and they wouldn't be treated differently. So it was basically concerns like that that we had. And then further, don't want to take up too much time. When we looked at the schedule, this is the 12th schedule. It's headed Dispute and Grievance Procedures, but then the headings speak to discipline. So we were not sure whether the bill was proposing that this would now be, part of the disciplinary process, because of course some aspects of what is contained there, it's not in sync with the Public Service Commission regulations. So we had those concerns as well.
Were you consulted in the run-up to designing and drafting of this?
No. We actually, well, I can speak for myself. The DP and I only received this on Tuesday, late Tuesday. So we actually only had Wednesday and Thursday to sort of look at it and prepare to attend today. So we'd be grateful if we have the opportunity to make written submissions as well. More detailed.
We welcome that. I could just, before I go to Member Indarsing, can I have a comment from the representative of the CPO in terms of the conflicts, if I can call them that, or the nebulous areas of remit that the legal officer for the Public Service Commission has outlined, in terms of if you have similar concerns as to where your remit is presently and as envisioned by the bill.
As was stated by the legal officer, we did not have a lot of time either to go through this in detail. However, in relation to the officers and employees of the statutory authorities, some are under the civil service regs, are covered by terms under the civil service regs, some are covered under the terms of statutory authorities. Personnel department has the same role or similar role for both members of the civil service as well as for members of the statutory authorities subject to the Act, and therefore we determine their terms and conditions after negotiation and consultation with the appropriate recognized association. In this case, it is the PSA. So we, in accordance with our role, which is stipulated in legislation, we will consult and negotiate for who represent the officers. So until we clear what is going to happen here, I would prefer to leave that until I get a little more clarity, and then we could probably comment on it a little further.
Thank you, Member Timal, and then Member Indarsing.
Yes, the bill in itself calls for extensive reform, and with the establishment of at least 12 distinct divisions, it signals significant increases in staff to adequately man and operate these divisional departments. From our previous engagement with the corporations, the committee was informed of several situations regarding the inordinate delays in appointments of present vacancies. And the committee is really concerned because of what is existing for present vacancies. And with this significant jump in having to hire additional staff, the concern is the period of time that it is going to take to really effect, engagement of all of this additional staff. So maybe the CPO could address this concern.
Chair, through you, Chair, I would like to clarify the personnel department is not responsible for making appointments. That is under the purview of the service commissions, in this case, either one. So we would not get involved in filling of vacancies at all.
Okay, so Service Commission.
Would the Service Commission comment on that, please? Given the challenges the Commission has had in the past in terms of filling present vacancies, and now these additional responsibilities are being envisioned through this bill for 14 corporations.
Thank you, Chair. As indicated previously, the Public Service Commission has powers to appoint and even, which means promote or even give acting appointments to positions that are under certain corporations. They would be the Shogunas, Diego Martins, Sawa Laventil, Tunapuna Piaco, Sangre Grande, Rio Claro, Princess Town, Hoover, Tabakit, Talparo, Pinal, Davie, and Siparia. So the offices that are under these corporations will be under the remit of the Public Service Commission and the Service Commission's department, which is the secretariat to prepare submissions to the Commission for the Commission to do handle them constitutional mandates. What I have observed over the last 9 months is that there has been an ongoing process of filling vacancies throughout public service, but particularly with the Ministry of Rural Development and Local Government. We have had discussions with the executive team early this year. I think it was either February or March, where we sat together to look to see what were the vacancies, the more critical vacancies to fill. And I wish to say that so far, some of the technical positions that we have filled already, there's a technical officer position. We have the county superintendent position, to name a few. But one of the challenges that we've been facing is that the Commission is not privy to the most recent performance appraisal reports of the officers who are to be recommended for appointment or for promotion. So what the Public Service Commission has done, they would appoint or promote subject to the receipt of up-to-date performance appraisal reports. So we are in discussions with the ministry to get that done so that the process of filling the vacancies will not be so protracted.
Just for us to get a context, would you have the information in terms of either by number or percentage, what percentage of vacancies presently exist even before what is to be envisioned is added to this? Could we get a sense of that in the corporations where you have remit that you've outlined?
I do not have that data with me because we are just starting to investigate this area, but we will be able to submit that to the committee.
Is it under 50% or 50? And I don't want to put you on the spot, but we want to get a sense of what we're dealing with presently to get a sense of what additional resources obviously you'll need to fulfill the mandates as envisioned in this. So if we get a sense of how significant it is or insignificant, we'd have a sense of what we're working with, even in the absence of the concrete defined data. Yes, 1 second. Yes, go ahead.
I will hazard a guess of possibly 45 to 50%.
Vacancies.
Vacancies to be filled.
To be filled.
Yes.
All right, I know.
Hazard a guess.
Yes. Member Amin and then Member Rambachan. Okay, go ahead.
Dr.
Yeah.
Rambachan. Thank you. Mrs. Parkinson, you said that you make appointments subject to the receipt of performance appraisals. What then are you assessing in making the appointments if you don't have the benefit of a proper performance appraisal? And the first question. Second question. Are these people allowed to go and act in the positions without the benefit of you having the performance appraisal or while you wait for it?
Through the chair, What we have observed is that once the Public Service Commission will appoint someone for the first time, we said first appointment, that's a particular period, and we would have looked at a particular performance appraisal report. Ministries and departments have been, permanent secretaries and heads of departments have been delegated authority to do continued acting appointments up to range 68, the permanent secretary, that is. So we know that persons will be acting based on the delegated authority process. But what we have observed is that, yes, they would have been placed to act with the performance appraisal for a particular period, but when the time comes for the promotion, the ministries and departments are of the view that that performance appraisal report can be used to assess the officer for further appointment. But the Public Service Commission is of the view that we need to have the recent appointment for filling the vacancy to ensure that the regulations, particularly Regulation 18, which outlines the criteria for promotion, that is, up-to-date performance appraisal reports are received before filling a vacancy.
Do you agree then that it's disturbing for a member of the public, tax-paying member of the public, to have to swallow the fact that people are being promoted in the public service or allowed to act on the basis of not having their performance properly assessed, and that people might just be abusing delegated authority as permanent secretaries to do that?
One of the criteria used for further acting appointments on the delegated authority is you must have an up-to-date performance appraisal report, or else the person who the delegation has been conferred upon will not be in compliance with the delegation. So that is monitored by our team, our monitoring and evaluation team, where the delegation is concerned. But where it comes to filling vacancies, it is the mandate of the Public Service Commission to ensure that the performance appraisals are up to date. If not, the Commission will not do the appointment or the promotion.
Member Nassing.
Thank you, Chairman. Mrs. Parkinson, based on what you have told Member Rambachan, I just want to find out what has been your experience in terms of the time period or delay in receiving these performance appraisals?
Previously, the delay was pretty inordinate, but the Public Service Commission, in making its decision, will ask the head of the organization to submit the performance appraisal within 7 days of receipt of its decision.
Could you give us a sense of what pretty inordinate means?
Well, sometimes we will have to wait possibly 6 months because officers, the performance appraisal reports were not done on a timely basis, sometimes for years. We will have performance appraisals up to 2015. We are asking the Commission to appoint or promote in 2019.
So you're making appointments based on 4-year-old assessments? Could clarify for us, please.
The Commission will not be making appointments on 4-year assessments. That's why, if a recommendation comes to fill and a name has been submitted, the Commission is requiring that the heads of departments and permanent secretaries submit up-to-date performance appraisal reports.
But as we speak, Mrs. Parkinson, I am, unless I am confused here, this morning, persons are now being allowed to act for what periods? Based on what you are saying and this in-audit time delays.
Is the acting indefinite or
indefinite? And you see, you create a legitimate expectation in a person when you have him acting for a year, 2 years, from an industrial relation point of view.
So it is now the mandate of the Commission to ensure that promotions and appointments are done on a timely manner, because it is recognized that people have been appointed to act for long periods of time, and even under the delegation, the acting is really supposed to be for 6-month periods. But we are, at the Service Commissions Department, are on a drive to ensure our records are up to date so that recommendations will be sent to the Commission for them to do the appointments and promotions on a timely manner.
Just a comment. Could we get a comment from the Statutory Authority Service Commission on if you are having a similar challenge or experience, please?
Thank you, Chair. At the Statutory Authority Service Commission, we're experiencing a similar situation with respect to the performance appraisal. Over the last 3 years, the Commission went out on an outreach program. So we have been visiting all of our corporations as well as our other entities, and we were ensuring that they understood the importance of this performance appraisal in terms of persons acting and appointments. The Commission has been very successful in getting performance appraisals submitted in a timely manner. Over the last 2 years, the Commission has also been on a drive to appoint persons, permanent appointments and promotions, and I can say that currently we probably have maybe about, and this might be overstated, 300 vacancies to be filled, which we expect to have most of that completed by the end of 2019.
Chairman, I need to have, I hear what you say, you visit and you're trying to get the performance appraisals and so on. Now, do you do any kind of spot checking to see whether these performance appraisals are just being done because you asked for them to be done, and that they are not done before, so somebody just comes and ticks off? Because how come you could be promoting people on the basis of performance appraisals, and splattered all over the newspapers for the last 3 weeks is the total incompetence of local government corporations in the delivery of services to their people? And yet, you're saying all of these performance appraisals are done and so on. Are these performance appraisals sham, or are these performance appraisals based on fact? And what perhaps are you doing to measure the goals that are being set for people against what is being reported in the performance appraisal? Because there's a big disconnect, Ambassador, between what the performance appraisals are saying and you're promoting and the actual performance of people as being depicted by the public.
Okay, so again, the Commission does not go out to do that type of spot checking because it's not, again, under the remit of the Commission to do that. What the Commission, because the Commission requires the performance appraisals to be done before the appointments can be done, the Commission took the opportunity to go out and do the training, right? Members of the Commission as well as members of staff went to the Commission, and we indicated the importance, and we actually went through how you do it and what is required of the officer who is doing the performance appraisal, what it is to do. So we actually did the training, right? To say that we would go and spot check to see if they're doing, I don't think we have the manpower, or neither is it in our remit to do.
Disconnect between the performance appraisals you are getting and making the promotion, because you're making the promotion based on somebody who is being reported to be a high performer. And you're making those promotions, you're making those appointments, and yet, the performance of the corporations leave a lot to be desired. So is it that we are promoting incompetence because the senior management of the public service, who are supposed to be on top of all of this, because it's a really difficult situation for me to hear that you now have to go and train people who have been appointed as human resource officers, people who have been appointed in senior positions to take on this task of performance management, and they have not been doing it. Listen, between what Mrs. Parkinson said and what you are saying, there's a serious indictment upon the senior managers in the public service here this morning. A serious indictment, not only of incompetence, but dereliction of duty.
Can I go to Member Garcia and then Member Hussain, please?
Yes, thank you very much, Mr. Chairman. I have 2 questions I want to ask. The first one refers to acting. What claim does an officer have with respect to permanent appointment if that person has been acting for a period in excess of 3 years? Is there any claim for permanent appointment? And the second question I want to ask is, it refers to local government employees. Tomorrow is a public holiday, and in the Ministry of Education, for example, all daily paid officers did not report to work because that is their right. In the regional corporations, the situation is the same. All daily paid workers are not required to work because tomorrow is a holiday. Is that still in existence? And what is the genesis of this?
Through Chair, I will deal with the second question. That is a part of the collective agreement between the union and the CPO and the unions representing the daily rated workers. I am not in a position to say how far back it has been in place, but that has been a negotiated term for them, and it is in place, and that's what's happening right now.
Now, I know that many of the issues that are being raised today are indirectly and directly related to the bill before us, which we are here to discuss. And because of the associated and implicated issues that the members are asking you questions associated and not directed to the bill, but I'm hoping that you can couch your language and your responses also in terms of if the bill addresses the concerns that are valid concerns that are being addressed by members in the context of if you see provisions in the bill specifically to deal with the issues raised, which as I said are valid issues, and if you think we need to include amendments to deal with those issues as they exist now in the corporations and as envisioned in the bill. I'll go to Member Amin and then Member Indas.
Thank you, Chairman. I really want to bring
one second, I'm sorry.
Sure.
Member Garcia asked a second question, another question that wasn't answered. If you could remind them, please, Member Garcia.
The question I ask is, what claim does a person have on permanent appointment if that person has been acting for periods in excess of 3 years?
Through the Chair, with respect to acting appointments made by the Public Service Commission, the officers who are appointed to act are informed by way of letter that the acting will fall within a particular part of the regulation, Regulation 26, if the position is not a prelude for promotion, and they would be informed that they have no claim for permanent appointment in the office, notwithstanding how long they have been acting.
Okay. Chairman, I see we are getting into some of the operational issues in terms of why people feel the Service Commission tend to be another layer of bureaucracy. It is very clear, I think, from the response of both the Service Commission as well as the Statutory Authority Service Commission in response to Dr. Rambachan, that there is need to double-check and verify. If these regional corporations are sending appraisals to you, and you don't know whether they are doing it the right way, or in fact, if it is a correct reflection of the performance of the employees, you must have some system to double-check. We have had numerous instances of officers, dereliction of duty, improprieties, corruption within regional corporations, insubordination, leaving the work early. And senior officers, if they do put anything in the file, it is not reflective of the true nature or the extent of the offenses. Some supervisors, it appears, might be intimidated, or they have a long-standing working relationship with some of these people to the extent where they don't want to put anything negative in their file. The file would reflect the entrance on the file would be reflected in the performance appraisals. And what you get is not reflective of the truth at the end of the day. And regional corporations have been fighting with that. It has been affecting productivity in a major way. And one would think that the service commissions would be there to ensure that the performance appraisal on which you do promotions would be based on the truth. And that is an area I think we have a big gap in. I also want to go further. Mr. Chairman, this is a point I've advocated for quite some time. Employees of all regional corporations, in my humble view, should be under one service commission, whether it is the statutory authorities or our special local government authorities, the service commission, so that you will have one thing happening across the board in local government, in municipal corporations. And I want to ask Mr. Chairman, I know the parliamentary person concerning the taking of notes for this bill is present. I want to get the views of the directors who are here from both the Public Service Commission as well as the Statutory Service Commission. What kind of arrangements do you have to ensure that the same thing happens in regional corporations, that one, that you are both responsible for, to ensure that you don't have disparity in the service offered, and if it is possible for us to bring all the employees of regional corporations under one umbrella service commission.
Okay. So, through you, Chair, we too agree that it should be under one commission. We have seen it more and more clearly with respect to the municipal police. Having gone through recruitment with respect to municipal police, where we have different criteria, we get complaints from municipal police, although they are not under our corporation, with respect to the regulations that are used to govern them, which is different to what we use. So yes, so in terms of that, we would want to very much agree with you in respect of that. Also, with respect to, if we look back at the bill, we see that there are areas where positions, currently, there are positions, even under the Statutory Authority Service Commissions, where similar positions with different designations, similar positions with designations, different designation with differing salary ranges. So, right? So what you are explaining and asking about, yes. And with respect to the bill, where we see Section 34 and 35 coming into play, and where the corporation is now having the authority to recruit, and also they have the authority to develop the structure, right? Which is what my chairman said earlier. We're hoping that the standardization of division also has the standardization of positions and also salary remuneration packages, right? Because we are currently experiencing those problems, although we are under those corporations are under the same commission, we have those problems. So with respect to the bill, we would like to get clarification with respect to Section 34 and 35. Also, Section 34 says that the corporation also has the authority to do qualifications. The corporations now, under the Statutory Authorities Service Commission and also the Public Service Commission, we go with the qualifications that are approved by the CPU. So again, if we're looking at the bill, we have to look at all of these areas and ensure that what is happening currently doesn't persist in the future.
Member Hussain.
Thank you very much, Mr. Chairman. And Mr. Chairman, permit me, I would like to acknowledge the Permanent Secretary of the Ministry of Rural Development, who has been on only 14 consultations throughout the country, and who has been on every Joint Select Committee, paying close attention to what is taking place here. Based on what Mrs. Ali just said, I have a question, Mr. Chairman, through you. The police, we are on a drive right now with municipal police, and we promise 100 police in each corporation and 200 in Port of Spain Corporation. Well, we'll find place to put them. Now, the drive is ongoing. 200 passed out earlier this year, and the next 200 will pass out about a month time. But the complaints have been getting, because this police is more into community policing, which is people want to see police in uniform on the streets, walking, at the schools, at the churches, that kind of drive. But what is have been a question people have been asking me, why one commission you have to have 3 O levels, and the other commission you have to have 5 O levels? I mean, and we all under municipal corporation, municipal police. Why? Why? And I have been, we at the Ministry of Local Government advertise the position and then pass on to OLEP and National Security. We find a lot of females applying now, and it's mind-boggling for a lot of people who are applying. Why some must have 3? I don't know if Mr. Barlow could say how much O levels you all have to. 5. One commission in the municipal police saying 3 O levels, the next commission saying 5. I would like this to be addressed.
And are these 3 O levels or 5 O levels above a certain grade, or they could be just bare pass?
Mr. Thomas?
Mr. Chairman, in relation to the position outlined or indicated by our member who signed, it is a matter that we have discussed. We have met with the Minister of Finance on this matter. Question of 2 different criteria for appointment, and we have not got a satisfactory answer. It still exists. You have 3 and 5, and we have been laboring under the understanding that something will happen in terms of the governing of that, which will change that situation.
But Chairman, I just want to ask, is Mr. Barlow, are you satisfied that someone with a bare 3 O levels can be an effective police officer at the municipal level? I mean, what are your thoughts on that? Or do you see additional qualifications to supplement that?
So it depends on the person, right? Sometimes we have, 3 officers. As previous, we had 3 O levels, and many years ago, just school even certificate. It depends on the individual and the way how they perform their task and the determinant.
Let me ask an additional question to that, Mr. Baldio. What is the present relationship so the public viewing and listening has a sense and understanding of what the remits are between the municipal police and the TTPS presently, and how is the training different, especially in the context of the disparity between the qualification necessary for 3 and 5, so that people get a sense of what is required to be a municipal police in the context of what they're required to do as different from TTPS?
Basically, same duties and responsibilities, but the municipal police is confined to an area, like the city of San Fernando, Port of Spain. TTPS is throughout Trinidad and Tobago, but we work hand in hand. Again, they have the same power for us, same duties and responsibilities. Wherever we are short or they are short, we assist in each other. At the end of the day, we try to work together, again, for the benefiting. I hear Mr. Hussein mentioned community policing.
Similar powers confined within a particular locale, I can imagine the public looking on saying, well, why are there disparities in the entry-level qualifications? And is there a different training for persons with 3 O levels entering as opposed to 5 O levels from your knowledge? What is the training like? Because if you have 3 and you have a particular intensified training curriculum, one could understand that you may be augmented into the position. But is the training different at all to your knowledge?
No, what the TTPS, we train for 6 months, basically. The municipal police are basic 6 weeks. But what we usually do, we have what they call in-service and refresher courses. So sometimes we invite the municipal police officers to take care, to come up to date with reference to laws, act, and all these things. But the TTPS train for 6 months, where the municipal police train for less time. So the details of the syllabus in the TTPS is more in-depth than compared to the municipal police. And they do the basic duties and responsibilities. Where we, in our section, we do criminal procedure, defensive, firearm. They do it too, but we go in more in-depth, sir.
And in 6 weeks, someone has the same powers as a TT police officer. Is that incorrect? I saw Mr. Ali respond. Would you like to respond to that, please?
Yes, Chair. The TTPS, I know they are 6 months. The municipal police, their training is almost 4.5 months. The difference, I think, is the number of days the municipal police train. They go from Tuesday to Sunday. They only get a Monday off. And the number of hours of training, I have been told by the Office of Law Enforcement Policy and the Police Service Academy, the number of hours of training is the same.
Mr. Baldi, also based on what hopefully you've been able to peruse the bill in some detail, do you think the bill adequately addresses the role and vision for municipal police moving forward in terms of their community approach to fighting crime and to engaging with the people at a community level, providing support?
Yes, sir. Mr. Hussain, honorable member, they mentioned community police. My commissioner is in a drive towards community policing. Community policing is good policing. Wherever community policing is practiced, Trinidad and Tobago worldwide, we have to bring back that level of safety and security. And I think working with the community, we can envisage trust and reliance on public by informants and cultivating informants and all these other things. When we worked out them, they feel they are part of us. So I think it's a good way to move forward. We could work with the community police as well as traffic wardens also in order to bring back a safer Trinidad and Tobago.
Would you advocate for a more robust training regimen then, given the role that you've outlined for community police? Because part of what being effective involves is having better tools through training.
Yes,
for community
one
police.
of the most important things is customer service. I think the TTPS and municipal police, customer service is vital really in moving forward with reference to Trinidad police service or policing as a whole. What we do sometimes have on a twice per quarter, what we call back most of these officers and bring them what we call a refresher and have them updated on the way forward. And if a situation happens, well, we'll do it as a simulator exercise and let them look. That is a situation, look, so if that should happen again, and we try to bring them up to date.
Indexing.
Thank you very much, Chairman. On this question of policing and community policing and so on, and what is the role of the municipal police officer and even the established police officer in the context of community issues. Within recent times, we have seen some very sad situations have unraveled itself in our society from the point of view of allegedly a young man killing his mother, another one killing his grandmother, and so on, and the issue of domestic violence and a number of social issues. And in the context of training too, from a social point of view, are these municipal police officers from a community point of view will be trained in dealing with persons who may be afflicted with mental issues and so on as we go forward?
Through you, Chair. I recall when we started the municipal police training about a year ago or so, that aspect of training was not included in the program. While the training started, representations were made for that to be included. And I think now it is included, even for street persons, treatment of street persons, and mental health.
Thank you. Member Tima has been waiting, and then Member Ramachan.
Yes, a lot of the discussions was about appointments and, performance appraisals and all those sorts of things. But in trying to get this legislation right, another huge challenge is really operationalizing this legislation. And with the respective bodies, particularly with respect to the filling, identification of new vacancies and the filling of the new vacancies. And just to give a little example, in the last session of Parliament, there was amendments to the Planning and Facilitation of Development Act. And one of the aspects of the amendment, one of the particular amendment, was the appointment of the chief planning officer, and Parliament was being asked to reconsider the original act with specified 10 years experience for chief planning officer. Parliament was being asked to consider reduction of that 10 years to 7 years, just because of probably market circumstances and availability of the resources that we have in the country at present. With the respective divisions, for instance, we are going to have 14 planning officers appointed. And in the context of availability of resources to operationalize the bill, I'm just using the planning officer as an example, but obviously it would spread through all of the divisions. Ms. Ali mentioned about the seeking clarification because of disparity between respective responsibilities. But in terms of operationalization and the committee being asked to provide clarification from where you all sit in with your respective responsibilities and what is before us, could we spin it around a bit and say, well, look, these are the clear conflicts that you are seeing with regards to your responsibilities and your remit. And in terms of getting this thing operationalized, this is ABC distinctly. When you get time to look at it more specifically, I think we would appreciate getting that sort of feedback from you specifically, so that we could address all the areas of conflict identified. I think Ms. Seacharan, the legal advisor to the Service Commission, did indicate, specifically that there are some areas of conflict, and if those could be submitted to the committee, item by item, not only from the point of getting the legislation, correct, but also the operationalization impacts that you all see and how we can deal with it.
I want to turn, if you want to respond first before, go ahead, please.
Chairman, I simply want to add that it's an area that the Statutory Commission has certainly labored under. We would like to see some clarification and some sort of structure that will provide for, if not a unified situation, but a clarity in terms of functions of municipal police vis-a-vis TNT police. And we'd be very happy to submit something to you or to the commission.
We'd welcome it. Thank you. I just want to be remiss of me, of us, I should say, not to more closely involve the Office of the Auditor General. And I'm reading from page 50 of the bill in section 113, Roman 1, and I'm reading from Roman 2, sorry. Inserting after subsection 3 the following new subsections. 3A, a corporation may, on the advice of the Auditor General, retain the services of an external auditor. And 3B, nothing in this section precludes the Auditor General or any auditor engaged by a corporation from performing a management of comprehensive audit of the activities of the corporation. Given what we've heard in many of the previous 7 stakeholder meetings about a lack of accountability, financially and otherwise, in several of the corporations, and anecdotal evidence from persons interfacing with these corporations, do the officials of the Auditor General, in perusing this bill, see that it goes far enough in providing stronger power, remit, auditing function to the Office of the Auditor General? Because one of the other issues is that audited financial statements of corporations have been a challenge for many years in holding corporations and personnel and financial officers accountable. And this has been one of the major bugbears, given in the past the limited funding going to local government, one, and then the seepage through alleged corruption. So from the perspective of the Auditor General, does this bill go far enough in providing you the tools necessary to have a stronger audit function and accountability in the corporations?
Through you, Chair, I'm not sure exactly what you're asking, because if you will note, number one, this bill has indicated that the accounts of the corporation will be functioning as if it was part of the public service. If it is part of the public service, then the remit, we have two remits. The bill itself, which has not been amended, says every corporation shall keep its accounts in the form having regard to its annual estimates approved by the Minister of Finance. And the accounts of every corporation shall be subject to the audit of the Auditor General. So that has not been changed. Furthermore, bringing it under the remit of the public service also brings into the consideration the constitutional right of the Auditor General under 116.1 to 116.7. So, in fact, the previous bill is already strong enough. What we were seeking clarification for was the amendment where it says a corporation may, on the advice of the Auditor General, retain the services of an external auditor. We are not clear there in what capacity the corporation would be seeking the advice of the Auditor General. Is it that they are going to be seeking the advice to obtain the external auditors for the preparation of their accounts? Is it from an auditing perspective? We are not quite clear. We are not quite clear. But to bring to bear that the corporations in themselves over the years have had some challenges in preparing financial statements. And I suspect that part of the reason for that is under which accounting framework will they be preparing these financial statements. The Act, the old Act, speaks to the accounting framework being determined by the minister under the approval of the minister. What you have is in various corporations, some will prepare modified accruals, some prepare cash basis, some would prepare, attempt to prepare accrual accounting when they do prepare accounts at all. So it is unclear to even them what framework are they, because there is nothing has been specified, nothing has been standardized as to what these corporations shall produce in form of an accounting framework and in form of a financial statement.
So with that said, and I probably shouldn't ask you to generalize, are you satisfied with what the corporations have been presenting over the years and the time frame within which they present these financials?
I think we would need to see that because the corporation has been, of course, been given, according to this bill, an expanded mandate. And in terms of that, they will have expanded responsibilities.
I'm asking in the context of you saying the legal remit already exists, is what you said.
Yes.
So my question is, are you satisfied based on that with what has been happening in the past, so we get a sense of the levels of accountability from the perspective of the Auditor General, where corporations are
I
concerned?
could only say that, you have a number of corporations who have not been able to produce accounts in a timely manner. And so that as a result of that.
And these are, if you have the list.
Okay, well, we have Sandy Grande. The last time Sandy Grande produced it was 2013. Tinapuna, their last financial statement is 2011. Shagonas Borough, their last financial statement is 2011. Kuva Tabakit is the most delinquent of all. Their last financial statement was 2005. Penal DB is not so bad. Their last financial statement, which we have at present received, was 2015. However, coming back to my original conversation in which the terms and the way the financial statements were presented were not in the most appropriate form. So although we did receive a financial statement, we did not accept it because it was not in a proper form of reporting.
But there's no mandate for standardized
At present,
approach.
we have not seen a standardized approach being recommended by the minister responsible under the remit of this legislation.
Have you been advising or requesting a particular standardized approach so that you can have an across-the-board assessment of the ones that are performing versus the ones that are not performing from a financial perspective? Because if you have different methodologies, it's very difficult to compare performance.
It is. it is. I would agree with you that. We previously, and many years ago, we did meet with the permanent secretary then, but that was quite a number of years ago, 2012, and we were given the assurance that the steps were working towards an approved format for presenting financial statements. To date, we have not received an approved format for presenting financial statements. As you know, our remit has to be an independent one. And so while we can make observations and we can cite, we would leave the recommending for the rest necessary departments that are responsible for that.
So, if I can answer your question for you, maybe take the liberty. You're not satisfied, given the information you've divulged here.
The accountability measures are not being served at present.
Thank you. Member Indassing.
Again, Chairman, just a couple of questions. One, and probably we would have touched on it, but from an operationalization point of view of the bill, Mrs. Parkinson, I heard you indicate, and I think Mrs. Ali too, Ms. Ali, that you have been meeting with the executive team of the Ministry of Local Government. Have you gotten a sense of how many additional staff that you will have to recruit if we are to raise the bar, realize this reform that is intended? Mrs. Pearl O'Brady from the Office of the Ombudsman. I, as a member of Parliament, I have seen people from time to time, constituents, come to my office where they have visited the Office of the Ombudsman. They are in possession of letters dating back to 2009, 2008, 2007, and saying, well, the Office of, or stating that the Office of the Ombudsman have written to a particular corporation seeking redress on behalf of an individual who visited the office. And based on what you are seeing here from a reform point of view, does this bill give you any sense of comfort that what is sought in terms of improving a person's standard of living or quality of life from what he's seeking from a local government point of view, whether it is a drain, a bridge or something, you see the Office of the Ombudsman playing a role, a greater role, that could get the desired effect from a local government point of view. And also, Madam CPO, I do not know if you have looked at 34A, in fact, the whole of 34 in relation to this particular bill from a pensions point of view, and you are in agreement how it can be realized, because I know for a fact there's an existing pension for monthly paid. But what is the status of pensions from a daily rated point of view? And also, if you care to comment that where the grievance procedure is now set out to be in the 12th schedule, you think that this has its role here in this particular piece of legislation or in the collective agreement, or you think that it has its rightful place here?
Chair, through you. Member, I would have to say that the Ombudsman is not satisfied with the powers he currently has in order to properly investigate matters. A review of our records showed that the oldest matter relating to the municipal corporation dates back to 2006, the most current in 2019. And the Ombudsman only has the power to use moral suasion in order to get these bodies to properly investigate matters. We wrote to the PS in 2019 asking that she intervene in having these matters resolved. Most of the matters are related to bridges, roads, repairs to areas in the municipal corporations. And as I said in my opening remarks, the responses that the Ombudsman would receive relate to funding, and in some cases, the funds are allocated but not released to the corporation, and when the funds are actually released, they are redirected to some other projects, so that the complainants are written to and told that the matter is receiving attention. And that is the most common response that the Ombudsman gets when he actually writes to have an update on the matter. However, I want to add further that Section 33 of the bill speaks to an investigation unit, 34, speaks to an investigation unit being set up in the council and giving them the powers to investigate. So the Ombudsman would want to seek clarification on that, in as much as 33G of the bill says that Section 93 of the Constitution applies to the Executive Council and the divisions of the corporation. But 93 speaks to the powers of the Ombudsman. So the Ombudsman would like to get clarification on that. And as Member Timal had indicated, we will write and indicate the concerns of the Ombudsman.
Yes, Mr. Chairman, I just want to state that the Office of the Ombudsman has been, or is supposed to be, a guardian of the public to ensure that where there have been failure to deliver, that citizens can have a second option to get something done. I think we can all agree that the Office of the Ombudsman is woefully understaffed and under-equipped to deal with the challenges that come out not only of regional corporations but throughout the country. And I support your call for greater powers to be given to the Ombudsman. Mr. Chairman, I also want to ask if the Office of the Ombudsman had any opportunity to have any input in this bill during its drafting, and if they would be in a position to submit something greater in terms of in writing as your reflections on this bill, as it has an impact on your office.
Chair, through you. I've been in the office since June of 2019. I would have to ascertain whether the Ombudsman has directly asked to have input in the bill. But from my research, the answer is no. And yes, we do welcome the opportunity to give written submissions.
Member Timal.
Yes, Chair, through you, I'd just like to come back to Ms. Pujadas. I think in terms of the accountability and what we have heard, I mean, it's really a horrible situation. And to compound that, what is going to happen is with the extended mandate under this proposed legislation, the corporations are going to be allowed to collect, to generate revenue, a lot of it coming through the collection of residential property tax with provisions for even industrial and commercial under special circumstances. And the inflows from this mandate is going to be significant, because the intention is that the corporations will be heading to a point of self-sufficiency in terms of revenue generation. And in the context of the present situation, and with all of this additional revenue streams coming in, it really paints really a bit of a frightening picture in terms of accountability. And my question to Ms. Pujadas is, in terms of the proposed legislation, are there any recommendations, if not now, but when you have more time to digest the legislation in its entirety, for any proposed legislation that would enhance the accountability of the corporations under this proposed legislation, if consideration could be given to that, to sort of give more teeth literally, to tightening up on accountability.
I agree with you that I will need to review it further in that context. But I would like to also point out that Section 109.1, as you said, is creating a corporation fund, of which part of the revenues will be generated, will be coming from the property taxes. However, the Act seems to still prelude that the regulatory framework should still be within the context of the Exchequer and Audit Act. This seems to be my understanding. Perhaps I could get clarity on that if that is the intention, but it is my understanding that that is so. And therefore, the financial rules and regulations of the Exchequer and Audit Act would continue to be applied. However, the new proposed act also seems to imply that the local governments will also have to produce their own regulations, and they would also have to have an audit committee and also beef up their internal audit processes. So I think there is an attempt built into the Act to improve some of the governance structures that at present exist. However, I think there needs to be a look at it from across the board holistically and consistency across each corporation, because we would not want a similar issue to arise in where those corporations that are under the first schedule have a particular paradigm, and those regional corporations that come under the second schedule have a particular paradigm. So there needs to be an assurance that there is going to be a consistency across the board, governance structure, and an accounting framework that is consistent across all the corporations. That's my preliminary assessment of the bill at this point in time.
Thank you for that, Mrs. Pujadas. So are you, I don't want to say suggesting, but do you think, therefore, that it will be very premature to go ahead with the details of these reforms without having those governance structures in place as they should be? Because, to have a corporation being run from 2005, as you say, to 14 years after you haven't gotten audited statements, millions and millions of dollars of taxpayers' money not being accounted for. And here we are talking about adding millions of dollars probably because of the new arrangements. Do you feel that, we should have those governance structures in place before, in fact, we move on to implement the details of this legislation?
As I said, I would need to look and have greater detail look at the legislation in a more holistic manner, but I focused on those areas. But any accounting framework needs to be operationalized from a position of governance. Your starting off position must be a clearly articulated and stated governance structure in order for the accountability measures and the transparency measures to be held accountable. Because if you do not have a properly stated accountability measure, then what are we reporting on? What are we saying? What are we saying? Your financial statements are true and correct in what view? From what view? A cash basis, an accounting accruals basis, a modified accrual basis? What is true and fair about it?
But it is disturbing to me that after all these years, the people in charge of the public service, even the Auditor General's department, have not come forth and suggested to the particular minister or what, that you should have a synchronized system. How come? How come you have been sitting over this as an Auditor General for all these years? You're seeing this thing coming before you all these years. You're seeing taxpayers' money with a big question mark. And as the Auditor General and Auditor General's department, you have not moved to write and say, listen, minister, government, you need to do something about this.
I think she did indicate, if I'm not speaking out of turn, Ms. Pujadas, you did indicate that you had some communication with DPS.
We did, and more than that, if those reports that we do submit and comment on, we always make reference to breaches in the legal obligation. And one of the breaches that we make reference to is the fact that there is no framework in accordance with ministerial approval. And so if you go back to our financials, our reports on the financial statements, our audited reports, you will see that we do comment on the legal obligations not being fulfilled. The relevant committees, is the responsibilities of the relevant committees to review those reports, and when they come forward, when the entities come before them, in conjunction with those reports, the committees, the parliamentary committees' responsibilities and remit, therefore, is to seek to find out why and what is being addressed.
Thank you. I want to redirect to Mrs. Parkinson and Mr. Thomas. In terms of what you see as the loopholes, in past stakeholder meetings, there's been quite a bit of concern raised about the nebulous nature of the relationships between the CEO and the council. And in Section 38, 2, in performing the functions above, the Chief Executive Officer shall act under the supervision and direction, and I want to underscore direction, of the mayor of the council. And 3, all chief officers and employees of a corporation shall take direction and report directly to the chief executive officer of that corporation. And to many of the persons who came before us, understanding of that is it is a shift in the modality that presently exists. And what your good officers see as the methods of clarifying this more precisely, and the implications of this shift in paradigm on the operation of the councils, especially given the fact that now, even with my limited experience, a council could be totally ignored, because this states that the chief executive officer shall act under the supervision and direction of the mayor. So if the mayor is not in concert with the rest of the council, you can have some possible chaos ensuing. Care to comment on that and possible remedies? If a remedy is necessary, in your opinion.
Yeah. Chairman, that's one of the areas that we have tried to seek clarification on. We're still working on it in terms of coming up with a proper submission. Mrs. Ali is going to elaborate on this if you permit.
Thank you, Chair. Section 38, as it's outlined, we actually looked at it, and we also looked at other sections that would relate it. And even in the interpretation, where they have the interpretation for mayor, right, and they have the mayor as the head, right, and then that's in 8 of the amendment, and also our regulation, the SSC regulation, that is how it defines the head. It defines the head of the corporation as the CEO, and this is defining the head as the mayor, right? So we definitely see problems there, especially as you go along now with the regulations of the SASC, where it has specific roles and functions for the head, right? So going back to what Member Timal indicated, that we've submitted in writing, while we would like to submit in writing how all of these things can be operationalized, or where we sit, how we see it, if we do not have clarity on these things, we will not be able to give you an informed analysis of what we are seeing, right? Because there are several sections that in the SS's regulation which would provide what the head has to do, right, in respect of discipline, misconduct, performance appraisals, the appointments, etc. So which head is submitting to the commission? We have no idea. Exactly. So if we can get clarity on that, we'll be able to give better
feedback and recommendations. Thank you, Mrs. Parkinson.
Yes, Chair. The framework that the CEO operates under, as far as I'm aware, the CEO reports to the permanent secretary. So this also we also need clarification as to who reports to who and what is
Now, what is
happening.
the relationship between the CEO and the permanent
CEO,
secretary?
Permanent secretary, and where the mayor fits. So this is something that we also will need to get clarification on.
Thank you. Members? We also like to get some from the CPO in terms of the schedule you referenced much earlier on and the pensions issue moving forward and the clarity you'd like on that.
Chair, there's some gray areas in this bill. We are seeing that the corporation can employ and that the terms and conditions will be determined by the CPO. Now, generally, there are three different kinds of employees. There are officers who would fall under legislation. There are employees who can be daily rated, who can be employed on contract. So we need to clarify if we're talking about a combination of all three. Now, if we're talking in 3A about a pension scheme, we have to take into account, as the member said, the officers have right now in the public service, in the civil service, a non-contributory pension scheme. The daily rated have workers, and there are three major unions that I'm referring to, which will be the NUJFW. We're looking at contractors who represent the workers at San Fernando Corporation, and the amalgamated representing Portersville. The arrangements are different. There has been a move to get a pension scheme arranged for daily rated workers. That has not yet happened for the existing workers. If you're talking about the other category, which is contracts, there's a different arrangement for contract employees. There would be a provision of a gratuity clause, usually, in a contract thing. So we need to be clear who are the employees of the corporation, whether we're talking officers, we're talking daily rated, we're talking monthly paid. So until that is clear, then we could probably get into whether we're talking a pension scheme, a new one existing or otherwise. With relation to the grievance procedure that member raised, it is on the 12th schedule. We reviewed that grievance procedure and noted that usually a step 4 in existing the current grievance procedure would be, for daily rated employees, would be that the CPO is step 4. The CPO has been eliminated in this grievance procedure. That is not something that can easily be done. It's usually a collective agreement with the recognized unions, and to remove a step or make a change in a step would require consultation and agreement with the recognized unions. We need to flag that. Whether it should be in the legislation or not, I won't get into that right now, but we certainly need to flag that if you're changing a fundamental step in the procedure, we will need to have agreement with the unions who have recognition for the daily rated employees right now. And if you're changing that, that cannot be easy. That will not be changed with a stroke of a pen. It will have to be changed with negotiation and consultation.
Thank you. There's another point I'd like to get some clarity on, but some responses from you, where there was a sentiment expressed that in section 17 on page 8, 17.1, the mayor, aldermen, and councillors shall be eligible for such remunerations as may be determined by the minister with responsibility for finance. And there was a view expressed by some that it should remain with the CPO and not move to the minister. If we could get your perspective on that, please, and the implications of that.
I would like to clarify first that what is existing right now is that the Salaries Review Commission recommends terms and conditions for the mayor, alderman, and councillor on the request of the president. They are right now under the Salary Review Commission, so there are terms fixed for them. If there is going to be a move to change that to the Minister of Finance, well then, that is something that will have to be considered. But terms are fixed right now. It's not by the CPO. It is really the Salary Review Commission. We, the CPO and the Personnel Department, we provide secretariat services to the Commission. So the Commission would, by constitution, would get the remit from the President. And once we get that remit, we will review the terms for the mayor, the alderman, and the councillor, because right now that's where they are. If you want to change that, there's another procedure.
Chairman, with your leave, I want to kind of go in a slightly different direction. One of the issues we talk about in terms of discipline and wrongdoing from employees of regional corporations, particularly with senior officers, and we spoke about their performance appraisal and so on. There has also been some discussion about having senior officers in regional corporations file their returns of their assets and liabilities to the Integrity Commission. These, to me, Mr. Chairman, a person who has questions answered to the Integrity Commission in terms of how they acquire their assets. And if it is found that these assets have been acquired based on wrongdoing or corruption as it pertains to their job, of course, their job should be at stake, or it should be reviewed whether they should keep their job or not. And I want to ask Mr. Chairman, if the service commissions or the CPO, well, it would more be the service commissions, has any way of taking reports from the Integrity Commission into consideration when they are doing performance appraisals to determine whether these persons will in fact be promoted or not. And I'm asking this because I know that there are officers in the public service who account to Integrity Commission at present. And I want to I'm asking this because it is my view that more officers in the regional corporations, particularly CEOs and chief officers, but who have signatory power and spend billions of taxpayers' dollars, should have to account to the Integrity Commission. But I want to know how reliable is the present accounting to Integrity Commission when it comes to officers, senior officers, where an offense comes up. Are these people going to have an offense and still be promoted?
Okay, so through you, Chair. Yeah. We haven't had a situation where we have gotten a report from the Integrity Commission with respect to, at least in my time, with respect to any infraction by any officer, senior officer or otherwise, in the corporations under the SSC's control. And if we would take that into consideration, that would be something that I'd have to look at to our legal officers to check with our regulations to see if it is possible or not. But at this point in time, I would not be able to say, but I can provide that in writing.
Through you, Chair, similar sentiments of the executive officer, I wish to reiterate. However, if there is a report that will come from anybody, whether it's the Integrity Commission or police, there must be a clear breach of the code of conduct governing public officers, and that will start the disciplinary process, where the commission will take the necessary steps once there's a breach. So right now, we do not look at the report of the Integrity Commission, but we just await a report that may have outlined a breach of the code of conduct.
Chairman, you see, the code of conduct may have been drafted before we even had the Integrity in Public Life Act. And it is my view that we have 9 pieces of legislation being amended in this bill. It is my view that the Integrity in Public Life Act should also be included. Should also have, so that senior officers, especially CEOs of regional corporations, could account. But Mr. Chairman, it is either for that Integrity in Public Life Act or the act that governs the the service commissions to include that where a person offends the act, that they would be subject to disciplinary action by the commission where it pertains to their job. Because a person cannot continue operating where they have questions over their head about their assets and their income. And as it pertains to their job, there are too many allegations, specifically with regional corporations, with officers who allegedly enrich themselves because of the position they have. They abuse the public. They continue to live lavishly, and there is no way for the authorities to question how they get their income beyond their salary, and to make it an offense. They continue to be promoted, and they continue to abuse their power. And that is an area, Mr. Chairman, we have to address with the law.
There's a question that I want to ask of the CPO, the PS, Public Service Commission, and the Statutory Authority Service Commission. Given the fact that I've realized you've done your homework, and commendably so, the number of new positions and divisions envisioned in this bill, to me, even with your present workload, suggests that you would have to do quite a bit of internal adjustments and probably petitions for more resources to deal with this. Have you started to look at that situation in terms of what you would require in terms of additional resources or restructuring of your operations presently to fulfill the possible mandates envisioned in this bill? I could start with Mrs. Parkinson and then go down the line.
Thank you.
What would the implications be for your operations?
Thank you, Chair. That we will have to sit down, myself and the executive, we'll have to sit down and go through what these new positions are, and we will also need to do an audit as to what we have to possibly make the recommendation for additional resources. We are strapped, we are short-staffed, but we are using what we have. So now that we will have the opportunity to go through the bill, and we will look at that, and we will probably give you a synopsis and possibly the data as to how we will do that in the future.
And if you could include that, because you see, very often, despite your hard work and your efforts, your office, the DPA's office, the CPO's office, the Statutory Commission's office, are based because of delays and bureaucracy, because you have a heavy workload and the system is quite protracted in terms of years and years. And now you're being asked to undertake quite a significant more responsibility without even being able to fulfill adequately what you presently have on your plate. So it's almost like setting you up. If your recommendations don't entail what you would need to effectively commit and fulfill what you are presently asked to do, in addition to this, to me it's going to be counterproductive if that's not factored in. If I could ask Mr. Thomas to also comment on that.
Chairman, the most we can say at this time is we have, in fact, considered that it is something that is very important to us in terms of the structure and in terms of the staffing. We will be submitting something if we're allowed on that question. Mrs. Ali could give you details of that so far.
Thank you, Chair. Chairman, the Statutory Authority Service Commission, even without even thinking about this piece of legislation, started to put its own house in order in terms of how it operates to become a more efficient and effective entity. Unlike the Public Service Commission, they are larger, we are smaller, so it is probably easier for us to do it. We have the establishments for our corporations. We have proper establishments done for each of our corporations. We have also a master seniority list for it, which includes all of the corporations. We have done our outreach. We have been doing training. Within our own organization, we implemented an electronic document management system we also upgraded our IT. We have almost completed getting the delegation for certain functions to the corporation, right? So we have been trying to put our house in order, and we have done a significant amount of appointments, and by the end of this year, our hope is to have very few vacancies, if any. The vacancies that we may have problems filling generally would be the technical positions, the medical positions, etc. And again, it's because of being able to attract persons to the corporation in these positions, given the terms and conditions that we have to work with. So those would be the ones that would be challenging to us. But in terms of the others, the commission is almost completed in filling almost all of these positions. So say the commission would be prepared for any additional staffing arrangements that would be a fallout of this bill to deal with any of those challenges. Because I think the Statutory Authority Service Commission is in a good position right now to meet that challenge.
Member Hussain.
Thank you very much, Mr. Chairman, again. I used to be a mayor in San Fernando, and now I'm at the Ministry of Local Government. And I get letters, I get phone calls every day. My question is, this level of people, cadre of people here today, I have the answers for all the questions. What about the people under you? Why it takes so long to fill vacancies? Why? It takes months, it takes weeks, it takes years. It takes so long to fill vacancies. So many young people coming out of the universities who have, you have children, they educate the children, and they come and they qualify. And it's taken so long to fill vacancies. I was a mayor in San Fernando. I had real problems getting people to stay. Same thing, I had a question for the CPO, and we can't attract people like financial officers. I don't know what's the reason, but why it takes so long to fill vacancies. I mean, I want to just deviate a little bit. There's a department, I think in the ministry, somewhere, and you have derelict vehicles in every ministry, in every corporation. I worked at the corporation in San Fernando for 40 years, and we can't get rid of derelict vehicles because they had to go through a border survey. It'll take months and years. I leave there after 40 years, the vehicle's still there. Why it must take so long to fill vacancies? We have competent people in our society, qualified people. I mean, this is a troubling, Chairman, this is very troubling.
Why would somebody professional run into that situation? And I understand part of the intention of the bill is to decentralize and modernize and professionalize the system. But if we don't iron out, as we're attempting to do in terms of getting feedback, the bottlenecks and the loopholes, professionals who even graduate from the universities are not going to walk into those frustrating situations. And many of the stakeholders before us, including your good selves, have told us about the frustrations you face. For example, just going back to the municipal police aspect of it, there are 1,500 positions envisioned, and right now there are only 434 positions filled. So from the perspective, and we're running out of time, from the TT Police Service, do you think you will be able to, in a medium-term setting, train enough people to meet the minimum standard of operation that is envisioned to augment the 7,000 plus TT police officers and work cohesively together? And what are the challenges with that?
Well, so funds to allocate the training. But we have a long list awaiting. Once the funds are allocated, we have a system in place that we could train. The amount of, what we'll do, we do it on a phase basis. We do start with 4 months. After 4 months, we make place, we send a 4, But at the end of the day, 6 months training, but we try to turn over as fast as possible. within that time frame to ensure that we are back up to strength.
And what is the monitoring, and excuse my ignorance, mechanism in place for municipal police? I don't know who can answer that. Because with any cadre of persons in any sector of society, you need monitoring for.
Mr. Chairman, I can answer that. Because I am very, very much interested in the municipal police. When I came into the office 3 years ago, my mandate was to fulfill this 1,500 police. And I must say, together with the Commission and the OLEP and all the stakeholders, the Permanent Secretary of the Ministry, we are working on it, and it will happen, and it is going to happen. This is one thing I want to make, just like local government reform is going to happen, because I haven't heard one person in this society say they don't want local government reform. This is a necessity, and this will help everybody, whether you're political arm or your administrative arm or you're just a lay person, local government will assist everybody in the society.
My question comes without casting any aspirations to the existing municipal police, is that when you ramp up recruitment and hiring in any sector of society without the requisite checks and balances, especially in this situation, we have had in the past public confidence and trust issues with the TTPS. And to me, without the requisite monitoring and transparency mechanisms in place, you don't want to take in 1,000 people and end up in a close proximity to communities with people who are less than forthright. And that's why I asked the questions about, in particular, the mechanisms for training and monitoring when it's a 6-week to 3-month training as opposed to a TTPS regular, and then you're putting them out there to interface directly with the public, and you don't have the mechanisms in place for monitoring their performance, their honesty, their integrity, etc. And that is, to me, another point of concern, where while it is envisioned to do good, if it is not implemented effectively, it can end up doing a lot of harm. Remember.
In your deliberations after this hearing here, I would like you all to give consideration to whether it merits consideration for a coordinating body, coordinating task force and interim, maybe short term, with members drawn from the respective bodies here to be set up with particular reference to operationalization of this bill, because it's obvious. There are areas, even the legislation won't fully clarify even after we consider all that has been discussed and presented. Because of the extent of the reform, it's a big challenge. So if you all could let the committee know in terms of whether a coordinating body would serve as a positive, would have a positive impact on operationalizing the bill. Please let us know.
Mr. Thomas. Well, I'll invite, because we're running to a close now, Mr. Thomas to open the closing remarks and give your response that you were about to give.
Mr. Chairman, first of all, to say that as far as we are aware, there aren't too many vacancies in the SAC. We have sought to minimize the question of vacancies, and we've done so through a whole process. The process itself is a slow process, but we have worked with it, and we think we've made tremendous achievements there. We've instituted also what is called now a delegation of authority, so that the different entities would have sufficient time and space to deal with that almost immediately, rather than to wait for the Commission to initiate that situation. The issue of funds, however, has proven to be quite difficult. And then, of course, we have what is called the lack of a coordinating body, where there are certain skills that are required and certain skills that need to be changed. There are some cases where the actual skill has been, shall we say, been for several years at one level, and what is required now is quite different. So we will welcome the question of a coordinating body that will look together at where we are, what we need, and what is the present regulation in relation to that. But maybe Mrs. Ali has something further to say on that. No? All right, thank you.
Thank you very much. Can I ask Ms. Pojadas, I pronounced it wrong, I apologize, for your closing comments, please.
Thank you, Chair, and once again, we want to say we appreciate being present here today. I give my context again in clarification in terms of the certain issues that imply on the finances of these corporations. I want to be particularly clear that when we are talking about the corporation statutory fund, which the legislation, the bill is proposing to have, that there is congruency between what it can do and the Exchequer and Audit Act, which the bill seems to imply is still in existence. I note in particular, the corporation indicates that the fund will also entail funds gathered from bilateral companies, multilateral lending agencies. However, the Exchequer and Audit Act specifically precludes statutory borrowings by way of bank overdrafts, etc., without the necessary approvals from the minister, and that is Section 36(1) and Section 36(2) of the Exchequer. So I just would like to make sure that in going forward there is congruency between the Exchequer and the intention of this particular bill. Moreover, in terms of the governance structure that would need to be applied, because the fund is now advocating that the retentions of monies collected would no longer be necessary for it to be deposited into the consolidated fund or to be returned. And so therefore there needs to be a mechanism in where there's equity of distribution of revenues across the streams, and also properly defined in the legislation, perhaps, as to what the monies can be used for with greater clarity. And that would also enhance our role as the auditors in addressing whether due diligence has been applied. So I just wanted to bring those matters into context. We do also have a stake as far as the pension issues was raised, because the pensions of the monthly paid and the daily paid of the corporations do come by different means and mechanisms to the audit office as a final vote for verification. So we also have an interest in terms of how that pension will be worked out as well. So thank you.
Thank you so much, Mrs. Sinisui-Gervais.
Again, I would like to say thank you very much for having the opportunity to come today. We do need some things clarified, as I said before, whether we are increasing employees as daily rated or we are going with increased contract employment. If it's increased contract employment, yes, it will affect the workings of the personnel department because it will be more positions that we'll have to fix terms for. If it's increased officers and employees, then they're going into the existing arrangement. There are terms already fixed for that, and negotiations, the process of negotiation consultation is what would change those terms. If, however, the bill is trying to create something along the lines of the RHAs, there will be a slightly different process to deal with terms and conditions, because the RHAs are considered public sector, and therefore the terms and conditions for employees in agencies like the RHA, like an RHA, will be set by the Human Resource Advisory Committee that I mentioned before, where we provide just secretariat services for that committee. And the committee will deliberate, provide guidelines, and our role will be to give the guidelines back to the ministry, to the corporations. So it's really, we need to be very clear what is really going to happen. As I said, it will also affect the pensions. It will affect the grievance procedure. We will still have your recognized unions to deal with, and making changes in the present collective agreement will require negotiation and consultation and agreement. So thanks again.
Thank you so much, Mrs. Pyle O'Brady.
Thank you, Chair. On behalf of the Ombudsman, I want to again thank the committee for the opportunity to be present here today to share concerns. Since the inception of the Office of the Ombudsman, through the Constitution, has only been able to make recommendations to government bodies and agencies with respect to matters of maladministration on behalf of the citizenry. It seems as though the local government reform is at the cusp of such reform through this bill, and the Ombudsman would welcome the opportunity to share recommendations with these bodies, given the experience we have had over the years with matters of maladministration, and particularly so with delays. This seems to be a prime opportunity for the Ombudsman to share these experiences and perhaps avoid future missteps and maladministration. However, where instances where moral suasion does not work, it may be now the time for the Ombudsman to be given the power through the legislation to make a firmer interventions in matters where the citizens are seen to be put in some undue distress because government bodies and agencies are not performing at their maximum. So we do welcome the opportunity to put these concerns and these recommendations in writing as it is laid out in the strategic plan that is proposed for the Office of the Ombudsman. Thank you.
Thank you so much, Mr. Baldeo.
All right. Again, Mr. Chairman, I really thank you all for the opportunity to share. I want to assure you, on behalf of the TPS, we'll work closely with the different relevant bodies to ensure that at least the city corporation, before it starts with reference to municipal police, we always welcome wherever training and things. I know you raised a concern about the evaluation, monitoring and evaluation. We recently set up a system, a monitoring and evaluation committee in the TTPS, and where there's a red flag, we pull in these officers and send them back to the academy to get them further training and, if possible, disciplinary action. As you have seen recently in the press, the police embarked on a no-nonsense approach to delinquent officers by the Professional Standard Bureau. We are committed to that and ensure that we work to ensure this will be a success. Thank you.
Thank you. And last but by no means least, Mrs. Parkinson.
Thank you, Chair. Again, on behalf of the Public Service Commission, we wish to really thank you for this opportunity to appear before the committee. And we also will look at the merits of the coordinating task force, which I think will be quite welcomed. And we want to let you know that we will be submitting our missive with respect to our clarification of the bill as it relates to the constitutional mandate of the Public Service Commission. And thank you.
Thank you. May I, on behalf of the substantive chair, Minister Ambarat, thank you all for being here, and thank you for being so competent and diligent in your preparation for today's discourse. I think you've commendably done very well, and we thank you for that preparation and your delivery. And we invite you, each and every one of you in your various capacities, to compile your assessments and recommendations and submit them to the Secretariat, and we will surely be able to factor them into our discussions moving forward. Thank you all so much. And we'd also like to thank the Secretariat for providing support to this committee, and this committee is hereby adjourned. Thank you so much.